Now back to Hello Houston. To comment on today's topics, call or text 713-440-8870 or email us at talk@hellohouston.org. Now here's Ernie Manous, Celeste Diaz-Sherman, and Frank Billingsley.
A major legal development in Texas could reshape how misdemeanor defendants are released before trial. Earlier this week, the Fifth Circuit ruled in favor of Attorney General Ken Paxton in a challenge to Harris County's 2019 bail reform settlement, opening the door for the state to revisit and possibly roll back policies that allowed most low-level offenders to be released without cash bail. Supporters say the reforms reduced jail overcrowding and saved taxpayers' dollars, while critics argue they made it easier for repeat offenders to cycle in and out of the system. To help break down what this ruling means for public safety and for communities across Texas, we're joined by Ken Good, a bail attorney and board member of the Professional Bondsmen of Texas. Welcome to Hello Houston.
Thank you very much for having me.
And if you would like to join the conversation, if you have a question for Ken, you can give us a call or text 713-440-8870.
So, Ken, where are we on this and where could we be?
Where are we? So the trial court has granted the Attorney General's motion to intervene to allow him to argue that the consent decree, which was entered several years ago, should be dismissed. The reason why he's arguing that is the Fifth Circuit, after the O'Donnell opinion was finished, it's subsequently been reversed, and it's been reversed multiple times, and the Fifth Circuit ultimately ruled it should have never been filed in federal court. And so Harris County's been following a consent decree settlement that had on a case that's been reversed. The rest of the state is following a different set of rules. And so I think what the Attorney General is saying, we've had SB 6 and SB 9 entered since the consent decree, and they're not following state law, and they have to follow state law. They can't enter into a settlement and change the law in Harris County versus the rest of the state.
Statewide, then, if you looked at it from that point of view, is it necessarily a bad idea? Isn't part of the problem we have overcrowding in our jails, and that oftentimes there are people in a situation who just can't come up with bail for something that is very minor? And if I'm not mistaken, isn't there already a provision in it for repeat offenders are not eligible for this program?
No, the Harris County model has all misdemeanors, but I think a list of 7 offenses. And if you're charged with one of those 7, then you don't get what they call a general ordered bond or a standing personal bond for $100, which is just your promise to pay. What the police officers union found in reviewing a 1 week's docket, that these cases had a 75% failure to appear rate. There's other sources that say it's over 80%. And so I think those create backlogs. They don't address backlogs. Backlogs create pressure to dismiss cases. When you dismiss cases, defendants see that as a green light to commit more crime. And you look at what else is going on in Harris County, where they had a press conference saying crime was down, and then 6 months later we discover that they had dismissed over 260,000 cases with the notation insufficient staff. Then you realize, okay, we're cooking the books too much, and we need to get back to just doing what we know works.
Wow. So, yeah, that's interesting. I did not know that. The crime is down because we're not prosecuting anyone.
I think that's probably true to a large extent. But, in Harris County, we've had a problem for a while, especially with misdemeanors, where people fail to show up for court for 17 times and they just get rearrested and then released on the same bond under the consent decree. And even on top of that, the consent decree requires they have to miss court 3 times before you can do anything to them. So you'd have to add the 3 on top of the 17. And what we've done is we've tied the hands of the judges so they can't do anything about it. And we've got to undo that and start complying with Texas law.
Help me out here a little bit, because this much more is your area of expertise than any of ours. But on the surface, it seems as though that it's a slanted system for people who have means, who have money, as opposed to those who don't. And if you don't and you can't get this money together, you are treated differently under the law than if somebody who has money and can get this together and can get out on bail. What do we misunderstand in that kind of argument, or is that an accurate argument?
Well, I think that's on surface the talking points of the people who are pushing for change. I think that it's a much more nuanced, it's a much more complex issue than that, because, there's a study that explains, what's the number one thing that impacts someone's length in jail pre-trial. You would say, listening to the activists, that it's amount of money or their ability to pay, but really the studies show that the length of time in jail pre-trial is your criminal history. And so the criminal justice system is intended to treat everybody individually. We want to give what amount of pressure is needed for you to change and become productive, and what I would need to be changed to become productive. And, if you're stubborn, you're going to need more pressure than me, because anybody can beat me up, so it's just not going to take much pressure for me. And what we're doing in this debate is we're saying we want to make it a cookie-cutter system, and that's not working. I mean, the people that are taking advantage of that are gangs, career criminals, and organized crimes. Even on our misdemeanors, they're learning where we're no longer prosecuting, and they're taking advantage, and they're making millions and millions of dollars out of our generosity. And so once someone is arrested and they have a criminal history, then they're not in jail because they can't afford the bond. They're in jail because the bond has been set at an amount because of their criminal history. And I think that gets lost in the debate. And we want to make it where we treat everybody the same. But the problem is the criminal justice system is intended to never treat two people the same, because we're going to do individually what's best for each person.
I was going to say, it sounds like this whole argument that, well, poor people can't afford the bail, and so it's discriminatory based on means. It's a fairly thin argument, if it's even an argument at all, Ken.
I would agree with what you're saying. It's a thin argument, but it hits all the talking points, and so I think it's worked for a while. But I think I saw an article today saying, have we uncovered that, bail reform is really not anything other than a political policy. It's not really good for public safety, and can we just let it die? And I think that's the truth. The O'Donnell case, which has started this, the consent decree that we're talking about, at one point in time, the O'Donnell case was cited across the country as the case on bail reform, and ultimately the Fifth Circuit ruled it should have never been filed. I mean, Judge Rosenthal has been reversed 7, 8, or 9 times in that case. And so I think what you're saying, it's true. That's all been a talking point, and it's none of the arguments that have been made are reality. And now Harris County has been hiding behind a consent decree for years when they're no longer following Texas law, and they don't want to, because they're doing a policy change through a consent decree.
We are speaking with Ken Good, a bail attorney and board member of the Professional Bondsmen of Texas. You're listening to Hello Houston on News 88.7. If you would like to join the conversation, you can give us a call or text 713-440-8870. I do want to go back to the O'Donnell versus Harris County case that you talked about, the lawsuit that essentially spurred all of this back in 2016. And it was essentially the case was arguing that Harris County's misdemeanors cash bail system was unconstitutional because it jailed poor people who couldn't afford bail. So my question then becomes, is clearly there was an issue during that time. And how do you make sure that people, yes, are, of course, public safety is top of mind, but there also has to be a level of, civility and making sure that people aren't just being left in jail? Okay.
I understand what your argument is, but that's not the argument that was made in the case. The argument made in the case is they found a procedural violation of the due process clause. And the procedural violation is when you went before a magistrate, they would tell you, do not say anything. You went to the magistrate for your initial appearance, and they would say, well, I can't afford this bail. And they said, no, don't say anything. Anything you say will be taken against you. And so they found a procedural violation of due process. And this whole argument that went on for several years, the judges were ready to give them a procedural remedy, but the plaintiffs wanted a substantive remedy, and the court eventually gave them a substantive remedy, forced release, when really all they needed was a hearing. And that's ultimately what the Fifth Circuit said. You found a procedural violation, so you need to give them a procedural remedy, which would be an opportunity at a hearing to say, I can't afford this bond. Please give me a lower bond. that's what the courts have ruled. But in the meantime, Harris County entered into a consent decree to require release and not provide the procedural fix. And so now we're not following Texas law, we're following Harris County law. And that's really the problem. That's the reason why the Attorney General has stepped in and saying we need to follow the same rules in Houston that we follow the rest of the state. Texas legislature sets policy on bail through statutes, not the Harris County, through a consent decree settlement with the plaintiffs.
So Ken, explain this to me. So before the reforms, judges in Harris County at that time, they followed a secured money bail schedule. Talk to me a little bit.
They had a scheduling order. Yes.
Right. So talk to me a little bit about how that often required cash bail for misdemeanors. Was that an issue within the policy?
Okay, so the problem was they had a scheduling order. So once you arrested, whatever your charge was, you had bail set off of that scheduling order. And so if you had multiple charges or you had a criminal history, it was higher. And so when you went for your original arraignment, there was no opportunity for you to say, hey, this bail schedule amount I can't afford. That didn't come up then. And that's the procedural violation, the due process violation that the plaintiffs identified, and that's what they sued over. The judges were willing to fix that probably initially and immediately, but that's not what the plaintiffs wanted. They wanted they wanted to require everyone to be released on a personal bond for $100, even though they found a procedural defect. So they got rid of the scheduling order. But they didn't require everybody to be they didn't require everybody to go before a magistrate and then have bail set. They just replaced the scheduling order of crimes to a $100 personal bond for all misdemeanors unless you're on the list of 7. And so no matter what your criminal history is, no matter how many times you're arrested, as long as it's not on the 7 excluded charges, you're going to get a $100 personal bond, which is not, you're not paying $100. You're not paying anything. You're making a promise that you'll come up. That's not complying with Texas law under SB 6. They have to review the criminal history before setting bail. They're not doing that. They're not complying with SB 9 in a number of respects, and they're in some situations they're releasing the defendant on what we call a GOB bond, which there's no such thing in Texas as a GOB bond except Harris County. Which is authorizing the release without seeing a judge or magistrate and without doing the public safety report. So all those things are in violation of Texas law, and they're still doing it in Harris County and Houston because they have this settlement consent decree in this case, which ultimately has been reversed by the Fifth Circuit, and they said it should have never been filed in federal court.
If you were rebuilding this system from the ground up, not with any of the rules or laws that are in place in the state of Texas today, would what you rebuild look like what the laws currently are, or are there areas you see this should be shifted?
Well, I've written an article on what does successful bail reform look like, and I to a certain extent, what's missing in Harris County is accountability. We've had several jurisdictions have to live under these preliminary injunctions until they went through appeal. And the problem is it ties the hands of judges and they can't hold anybody accountable. That's what's going on in Harris County. They keep being released on the same thing, and we keep expecting a different result, but they keep missing court. And so I think that what's missing is a strong level of accountability. So I would also point to, there's some studies from California from COVID that point to if you release people on a nonviolent offense, one on a personal release, which would be a personal bond, and one on a private surety bond, the person that's released on personal release or simple release has a 200% greater chance of committing a new violent offense in the next 18 months. So with that kind of data coming out, I don't know, you would want to make a personal bond the exception, not the rule, like we have in Houston, Texas.
Well, we do have a call. Mike is on the line from Katy. Mike, what is your question or comment for Ken Good?
Hi, Ken. I've been listening, and I'm a little concerned. My concern is that people with money have an advantage in the legal system compared to people who don't. So what steps are you taking to make sure they don't have an advantage?
Mike, thank you for that.
Okay, so to get an advantage, you've got to say you've got something comparable to the private surety bail system to take its place. I would point out there was a former judge who was a mayor that was on a News Nation a town hall meeting. She said, until you have something that has the same low failure to appear rate as the private industry bail system and something that has the same high level of accountability, you don't have an alternative. So anything else that you use does damage to the criminal justice system by increasing backlogs. And you've got a lot of pseudoscience reports. You can look at the Google and search, and you come up with all this pseudoscience that's not correct. It doesn't represent what the academic scholars are showing on bail reform. And so I would say that there are systems in place. If you're a first-time offender and you're poor and you say you can't afford a bond, especially for a misdemeanor, there are systems in place. And the existing law that's currently in place says we can't just hold somebody for a misdemeanor through delay. If they're still in jail after a month, they have to be released for delay. And on a felony, it's 3 months. So we already have protections into the system that don't get talked about and get ignored, in fact. And what we have are these talking points. And, when it's a $500 bond, I mean, what's it cost to get out of jail? It's not costing $500. It's probably costing $50, $75. And today's, the bondsmen today, with the way the economy is, the way they do payment plans, I mean, except for in Harris County on really serious offenses, I don't know if I agree that ability to pay is a preclusion to getting out of jail. In years past, the criticism at the legislature, we weren't working with families. Now we're working with families too much. Yes, ma'am.
I guess that's the concern. I think the concern that Mike was trying to say was that where does the balance fall within equity for those essentially that can call a family member up or have the means to be able to say, yep, no problem, $50 is not a big deal. It's chump change essentially, or $500 or $1,000, where you have people who also, even though there are support services that the decree calls for, additional support services like social services, help with transportation to court, child care, etc., I do think that there is concern a little bit when you start putting these bonds on people that you're setting them back.
Okay, I would actually disagree with you respectfully.
Sure.
I think when you're giving someone a personal bond and they have, let's compare. You've got somebody on a private surety bond and it has a less than 10% failure to appear rate, and you give someone a simple release, a personal bond in Harris County, and that suddenly they have a 50%, an 80%, a 75% chance of failing to appear. You're putting them in a worse position once we correct the system and put accountability on it. I mean, do you realize that when you miss court, you can have charges filed against you for bail jumping? And so if the courts were to do that more in Harris County, then we're putting someone in a worse position just by the type of release that we're allowing them to use. Mm-hmm. I agree with what you're saying if they were comparable systems, but when when we're putting someone in a worse position by the release mechanism, I respectfully disagree with what is being argued.
Could a lot of this all be fixed just by a better court scheduling with arraignments, hearings, court dates, all that? That's really where the problem lies in all this, is the delay before people are actually heard, or are we wrong?
I agree. I think that is part of the problem. We need cases to get resolved. We need to get justice to victims. And I actually think this new system in Harris County has actually slowed down the criminal justice system because you have to miss court 3 times before they can do anything to you. And when we started pointing out, or I think when the Sheriff's Association started pointing out that the failure to appear rates were so high, one of the things they did is they just started not requiring people to come to court. And so you only have to come to court when you're going to plead or when you're going to go to trial, but the rest of the time you don't have to come to court. And so that's the reason why you're seeing a lot more dismissals, because they can dismiss the case if the person's not in court. And so, I looked at the stats on 1 month, and by the end, they were dismissing over 90% of the cases on a monthly basis on misdemeanors in Harris County. So, we could save a whole bunch of money by just getting rid of misdemeanor courts if we're going to dismiss everything.
Ken Good is a bail attorney and board member of the Professional Bondsmen of Texas. Ken, thank you for joining us today on Hello Houston.
Yeah, thanks, Ken.
Thank you so much for having me.
Thanks.